We'll go ahead and call this meeting of the Ports and Marine Resources Committee to order. We've got 4 bills on the agenda to take up today. First one that we'll start with is Senate Bill 2647. It's the Mississippi Comprehensive Coastal Conservation and Restoration Act of 2024. Those of you who've been here have seen this bill or a version of this bill over the past couple of years. Basically, what we're trying to address here is providing a plan, putting a state plan in place to provide for the coastal conservation and restoration monies that the state of Mississippi is receiving and administering from various sources. For those of you who may not be as familiar with it, we've got GOMESA and some other NOAA grant monies that run through the Department of Marine Resources. We've got the Restore Act monies, which are the civil penalties the state was awarded from the BP program. A portion of those monies run through the Department of Environmental Quality, and the others run through MDA. The idea here is to put together an advisory board of stakeholders in the area that have science, the scientists, the biologists, the fisheries and water quality guys who can formalize a plan. And the plan would be to identify what the issues are that the resource faces, both in terms of stormwater protection, habitat, or land loss, water quality, those types of issues, and have some proposed solutions. And then that the Department of Marine Resources, Department of Environmental Quality, could use that plan as a resource for when they're determining project selection and things like that. It does not have a requirement that those projects have to come back to the legislature. It's still, the departments would still administer their own projects and do their own project selection. This would just provide them a tool with input based on science from stakeholders in the area that they can use as guidance. For the committee members, I had asked Pierre to take a look at this back, I guess, at the end of 2022. And in June, they came up with a report, and I sent you guys today a summary of that report, and as well as a link to the report. Basically, what Pierre concluded is the legislature should either consider establishing a formal coastal resiliency and restoration coordinating committee to establish a plan to monitor the impact and effectiveness of the state's restoration efforts, or require Department of Marine Resources, DEQ, and MDA to coordinate to develop a plan and submit it to the legislature every year. What this bill does, Senate Bill 2647, is puts together an advisory board, and that advisory board sets up that plan. Looking briefly at the bill, Section 3 creates the advisory board, and on there you've got a chairman appointed by the governor, representative from DEQ, representative from DMR, representative from the Secretary of State, because there is some interplay between what DMR does and the Secretary of State's jurisdiction of the islands, representative from the University of Southern Mississippi, representative from Mississippi State, a representative from a nonprofit, and then you can have legislators serve as non-voting members. The Technical Advisory Board is tasked in Section 4 with developing that comprehensive coastal conservation and restoration plan. And in Section 5, once the plan's in place, the board will prepare an annual report, basically monitoring how those projects are going. Are they having a positive impact on the areas of concern that were identified? And and that would be used as a basis to be able to look back on some of the projects and how they're developing. That's a brief explanation of the bill, as brief as I can make it. Happy to entertain any questions from the committee. Senator Carr?
Mr. Chairman, is this the bill that you've been working on for about the last 4 years?
Senator Gordon?
First of all, I want to say thank you very much for your efforts to do this. I know that's something that we've all been trying to help facilitate additional conversations and joint conversations amongst all agencies to ensure that we're meeting the needs of our coastal resources and trying to address all the big picture items. Currently, there are some specifically BP projects that are ongoing through DEQ. They have contracts that are in place now. They have projects that are in place now. I want to make sure that that you can speak to the fact that we're not trying to change anything, any of the contracts or any of the operations within the individual agencies, whether that be DEQ or DMR. This is really as an effort to have the executive directors, the executive directors of agencies, as well as interested parties are able to coordinate our efforts as we move forward in the future. And it's not going to affect any of the existing contracts that are in place. Is that correct, sir?
That's correct. There's nothing in the bill that dictates project selection or administration. The departments and agencies, they still pick and administer the projects. What this does is it provides a comprehensive tool that where this board's already looked at the areas of concern, proposed some solutions, and when the departments are picking those projects, they can use this, they can look to this plan and see how it fits. It also provides some formal collaboration between DMR and DEQ and MDA when it comes to project selection or just agreeing on what those needs are. There's nothing in here that would have a look back that would affect ongoing projects or even anything prospectively that would dictate project selection.
And as a follow-up, Mr. Chairman, this would also give the legislature an opportunity to have a resource, to collaborate with other agencies all in one place for us to understand how we can best program the dollars that are available for the legislature so that we are not either providing duplicative dollars for programs or that we let something fall through the cracks that is very important for our marine resources. Is that correct to say as well? Thank you very much. I appreciate it, Mr. Chairman. Thank you for your work.
Any other questions, Senator Hobson?
Thank you, Mr. Chairman. What is the amount, what's the expense or the necessary appropriation to DMR? I'm assuming this comes through DMR for this tab.
Well, the tab would be housed at DMR, and I believe there is
It's a per diem. I see it's a per diem and mileage. Do we have an idea about how often they would meet and what the cost is going to be?
I do not have a fiscal note on it, but the department is allowed to use a certain percentage of the monies that, for example, from GOMESA for administration costs.
Would this be part of that cost or would this be above and beyond the amounts that they utilize for GOMESA right now?
My expectation is this would be part of those administration.
Okay. You've spoken to the general on that?
We've discussed it, not this session. We did talk about last session, how it would function inside the department.
Okay.
And I'm happy to have follow-up conversation.
I can follow up with him too. All right. Thank you, Mr. Chairman.
Any other questions from the committee? Seeing none, do we have a motion? You've heard the motion. All in favor? Aye. Opposed? The next bill is Senate Bill 2648. You may remember last year we ran a bill to create an oyster bottom leasing program in the state of Mississippi. It was envisioned that bill from there would be an RFP. There was an RFP process, and the department, we we discovered some technical issues within the RFP process that had to be addressed before we could go forward. Those changes start on line 125. And basically, there were some issues with what the criteria were for the lease applicants. For example, there was some language about having some financial response, that the applicant would have to make a showing of financial stability or responsibility to actually perform the lease obligations. That wasn't very well spelled out either in the legislation or the RFP notice, but regardless, we've gone ahead and fixed and tried to fix that here. That's the language on lines 125 down to that's around 130. Other technical changes throughout is that the applicant who's seeking a lease must be able to show experience in the propagation and cultivation of oysters, and that the lease application promotes the maximum utilization of state resources. And that can mean a couple different things in the practical application of it. For example, we had some language in there about the lease areas had to be square, but that doesn't fit our actual permitted areas that are available to lease. Some of them are kind of odd shaped triangles or whatever. That allows the department, that affords the department some discretion when they're awarding those leases. Go ahead and make sure that they maximize for the production of oysters. Towards the very end of the bill, starting in line 492 and over down to 501, there is I guess we're increasing, Rick, we're increasing the penalties for anyone who's convicted of stealing oysters. So that's kind of the technical fixes that are in this bill. The goal is to roll another RFP out this summer after we sign a die and get this program up and running. Brief explanation. Any questions?
Thank you, Mr. Chairman. I've had some constituents that have called about about this particular RFP process, and some of them welcomed the restart on this process and fixing some of this legislation, and others have questioned why it was necessary to throw out the original awards and go to this. And it's my understanding that that upon review of the RFP and comparing it to the law, there were some dramatic issues that were legal cases, or that could result in legal cases against the state of Mississippi. And to avoid some of that litigation, it was determined by DMR to seek a legislative fix to this. Is that the general gist of this?
Example, one of the issues in one of the lease awards, the applicant had identified 4 areas on one reef that he desired to lease, but those areas were less than 1/4 of an acre each. He would have basically tied up 100 acres with these very small leases kind of positioned on this one area. So that kind of thing, we had to provide the department some discretion to be able to address those in the applications. That's what these said.
But we're still allowing the agency to come up with a scoring schedule for the RFP, and we're not messing with that at all in this legislation, correct? Okay, and then the people are, I'm not asking you to speak to every single applicant that wanted a lease in this area, but do you think that there will be those that will be disqualified from the RFP process because of the changes that we made here?
Well, there may be some that lack the qualifications or experience in oyster production who may not qualify under
Okay, but the new law is really restating the legislative intent from day one. We wanted to make sure that whoever would receive the bottom leases did have the experience and did have the knowledge of how to procreate oyster beds and to keep them lively for a number of years and sustainability. Is that correct? All right. Thank you, Mr. Chairman. I appreciate it again.
All right, seeing none, motion? Heard the motion, all in favor? Aye. Opposed? Senate Bill 2653 has come to us from our ports. The repealer on this bill, what this current law does, under current law, allows the ports to use a design build method for contracting for renovation or repair or improvements made to their facilities. That was set to repeal at the end of this year. This extends the repealer until July of 2020. That's an explanation of the bill. Are there any questions? There's the link.
Motion at the proper time. All sufficient to pass.
Heard the motion. Any other questions before we move on? You've heard the motion. All in favor? Aye. Opposed? Ayes have it. Last bill on the agenda for today is Senate Bill 2654. And this is a bill that was requested by the Department of Marine Resources. And basically, the department would like to have an administrative hearing officer that they could designate for any sort of permit, dispute, or anything like that. The way it's set up right now, the director hears the dispute, makes a recommendation to the commission. The commission determines, or well, here's whether or not there's been a violation. Here's the charge, or I guess alleged violation. Makes a presentation to the commission. If there has been a violation, it goes back to the director to administer whatever fines or levy whatever fines would be appropriate for that violation. Think about things like boathouse permit, like a boathouse built without a permit or exceeding its permit. What the department's seeking to do here is to put a stopgap, I guess, or an additional set of eyes really between the alleged violation and the executive director so that he's not, quote unquote, judge, jury, and execution. It does require the hearing officer come from within the department. Come from within the department, so it's still a department employee, which on the one hand gives me a little bit of pause, but because he's still working for the executive director, but it does provide a sort of independent or set of eyes before a violation goes to the director for purposes of levying fines or whatever. Rick, is that a pretty fair representation of the bill? Okay. Are there any questions about this? I will tell you that between now and when I bring it out on the floor, I haven't had a chance to do it yet with this particular bill, but I do want to spend some time looking at where this hearing officer type role may be already in existence in some other agencies and see how it fits. But that's a brief explanation of the bill. Any questions? Senator Hobson?
Thank you, Mr. Chairman. Currently, the appeal from the DMR decision would be to the Chancery Court, correct?
Currently, I think that's correct, yes.
Uh,
I don't think that. Go ahead, I'm listening.
the executive director's decision is appealed to the Chancery Court. Is that what I'm seeing on lines 98 and following?
That's correct.
And this officer, that's the compliance officer that's put in place, this is just an extra step before it gets to the commissioner.
Here it goes. So the steps, as I understand it, would be the administrative hearing officer would first hear the violation. He would make a recommendation to the commission. Then the commission would make that recommendation to the director, and it would be up to the director to make that final decision regarding.
So it goes to the director, the commission before it goes to the director.
Correct.
Where does the compliance officer fit in this?
compliance officer's on the front end of the violation, and he make that recommendation. The way it's set up right now, the director is making the recommendation to the commission, then it goes back to the director for that final determination. This takes him out of the process on the front end to where he's not coming in. So when he's making his final determination, he's looking at it fresh. He's not handled it before.
Yeah, my concern, it seems like it would go, the logical way would be go to the director or his or her designee, maybe, and then it comes still through the commissioner on to the commission. Typically, that's how things work. I'm not sure it's the case here. It sounds like what you've got set up is it goes, before you get to compliance officer, before you add that right now, it goes commissioner, commission, back to commissioner.
And that's one of the things I want to clarify before I bring this up.
Yeah, that obviously doesn't make any sense. But it's, while I have not spent any time looking at this, it just, I don't want to put more layers of bureaucracy in trouble. It seems like the best thing is you got a person, either whether it's the commissioner or a designee, that makes the recommendation after hearing it. And then, again, it seems to me if we're going to have that person there, it ought to go to the commissioner next, then the commission, then they can appeal it to court. But I may have it backwards. I may not do DMR as well as I should.
No,
Because that just seems backwards to me that your commissioner would, or anybody would send it to the commission, then it goes to the commissioner.
To the director.
Yeah, the director. That's what I meant to say, the director, not commissioner, but Joe.
And that's one of the things I want to spend a little bit of time with this bill before we bring it out to make sure that I've got a little bit of thought about, the hearing officer still works for the department, so he's
Mhm.
still
Yeah.
under the director.
That's a little unusual.
That's one of the things I want to,
Yeah,
alive,
I
but-
think two layers, pardon me if I may, it just seems to me two layers through the commission, which would include the director, is enough before you get to court, rather than making somebody come 3 times for hearings on it. And I know what you're trying to do, and that makes sense, is try to see if you can get rid of some stuff before it ever gets there, if it's not worthy. But I just ask you to look at that. I'm not totally satisfied with this as a finished product, but I'm happy to move it along to keep it alive for some discussion. It just doesn't seem like it's the most efficient way of doing this.
agreed.
Yeah, thank you.
Thank you, Mr. Chairman. Senator Williams. Chairman.
Along the same lines, question, the final decision, the intent is that the final decision is by the director?
That's correct. That's in lines 161 through 169. If you look on subpart 2 there, the commission's recommendation is for the executive director who will make the final decision.
So the commission is recommending to the director,
Correct. In his current form.
right, which I go back to what Senator Hobson was saying. If the whole point is to put somebody in here in the middle and I'm sure all of us have been caught in the middle of these permit disputes to do there, it seems to me like it is problematic to have the officer, an employee of DMR. And so it seems like it should be an outside independent person who makes a review. And then I also noticed that once the director makes it, if they're not happy, then they go to Chancery Court.
Correct.
Which then makes it, you're preserving whatever you want to call it, the objectivity. So, and then that makes me think, well, maybe we need to, what normally happens? Do we get paid? Do they get paid, or is it a volunteer? To be honest, I don't know that the volunteer is going to want to volunteer for the permit disputes that get.
Agreed.
So, okay, that's what you're looking at.
That's I have similar concerns. Like I said, this is something that the department asked for. I'm willing to work with them to try to get a better understanding of what the concerns are and how we might be able to address those concerns in this bill. But with the understanding that this might not be the final product, maybe the prudent thing to do is
Well,
put a,
then I'll say that's why, so on line 35, it seems to me there should be some language that says either compliance officer procedure within or compliance officer, process and not within. So I assume you're gonna bring up an amendment or something?
an amendment with a reverse repeal would be friendly
Okay.
at this time.
Okay, I will so make that amendment
Okay?
with a reverse repealer.
You-
To put a reverse repealer.
Okay, you've heard the amendment. All those in favor?
I,
Opposed? All right.
reverse repealer. Not yet. My amendment, that was a long way to get to the reverse repealer, yes. Right. Yeah, but we shoot for more objectivity down on the coast, Bob, and, so we're above board. Yeah, above water.
Mr. Chairman, I may have this a little bit out of context, but we're talking about violations that are brought forward by who? Or whom? In other words, who cites someone for a violation? Is that what this compliance officer is going to do? Is he going to be, is this like a code enforcement officer with the city that rides around in a boat or rides around somewhere looking for violations to all of the DMR stuff, including coastal zone consistency and wetlands of uplands?
I'd like to ask, Rick, can you speak to that at all, or?
Can you speak to a mic? Because and the reason why I'm asking that is that we've got a couple of people that are watching online that are having problems hearing some of the debate.
So it's my understanding, to be separate from that, we have employees in the field that already, you know, that can notice these issues and notice these violations, but there's also the public that makes complaints. If somebody says, well, somebody's building a pier without a permit or whatever, there's these complaints. And that, it's my understanding that those complaints would come to this compliance officer as well, but if there's violations, they would go through the public.
Okay, will this proposed compliance officer, is he going to be another cop on the street, if you will, that's going to try to go around and seek violations? So this is just strictly administrative. Whenever a complaint is received, then from a desk, they're taking statement of facts and trying to understand what the agency has found, other department or other people within the agency have found, and then they hear the other side of the argument from the homeowner or the landowner. Is that what we're trying to do here? Okay. All right, Mr. Chairman, I just don't want to create another layer of cops that are running around citing landowners to where we don't necessarily have a problem with it right now.
Disagree. Any other questions from the committee? Heard the motion, all in favor? Opposed? Ayes have it. So moved. Yeah, that's what you did say.